All right, so we are convening, as mentioned, for a hearing on motion in case 2025 M42. The defendant is Ms. Jasenia Amber Raby. Ms. Raby appears today via WebEx. Ms. Raby, ma'am, it's Judge Murphy here. Can you hear me okay?
Yes, Your Honor.
Terrific. All right, and thank you very much for your appearance today. I hope you didn't get as much rain as we got overnight, so you probably were going to be in worse shape trying to navigate the roads today. But
fully, completely washed out. So.
Oh, well, I'm sorry to hear that. Okay, so let me just give you an overview of kind of the way this works, because since you're representing yourself, I just want to, let's just start with that question. Are you comfortable continuing to represent yourself or for purposes of this hearing as well?
Yes.
I'm sorry, was that a yes?
Yes, sir.
All right, thank you, ma'am. All right, so the procedural history here is that on August 5th, 2025, when you appeared personally, you submitted to the court a lawful challenge to jurisdiction, standing, and authority, as well as an additional, that's a 2-page document, and then an additional 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction. So generally speaking, the party who makes a motion goes first and argues his or her assertions. You don't have to, if you want to just stand on the pleading, that's what we call it. If you want to just say everything in writing is all I have to say, you can do that. But I want to give you the opportunity first to be able to run through the various points that you have. Then the people, and Mr. Bama is here on behalf of the people of the state of Colorado, the people will offer their position as to your arguments, and then ultimately I'll have to make findings and then either grant or deny your motion. So with that said, did you want to go ahead and begin with anything you want to state?
Everything I have to say is in writing.
What she's really saying is that all her arguments are written down, just not in any meaningful way. It's basically nonsense on paper. But don't worry, the judge is about to step in and deny all of her motions one by one. Before that, though, we'll hear from the officer, whose testimony will lay out the foundation of what actually happened and explain why this case even got to this point.
Okay. All right, ma'am. Thank you very much. Mr. Bama, sir, do the people have any argument to make with respect to this motion?
Yes, Your Honor, we have argument that we do have a witness. Caitlin Bills is on WebEx.
Okay. All right.
I intend to call her briefly.
All right. Very good. Do you want me to swear her in?
Yes,
now?
please.
Okay. Deputy Bills, ma'am, good afternoon. Are you able to unmute yourself and switch on your camera?
Yes, sir. Sorry, I'm trying to get my camera on.
No problem. I know it's a little cumbersome, so thank you very much for your appearance and your getting the WebEx machine thing to work.
Yeah.
Okay to self?
Yeah, you can mute yourself. If you want to say something, just raise your hand and get my attention, and and you'll have an opportunity, Ms. Raby, to cross-examine Deputy Bills. So what'll happen is I'm assuming Mr. Bama is going to walk through some direct testimony or solicit some of her direct testimony, and then you'll have a chance to cross-examine her. You can ask her questions about what she said during the course of her testimony. You don't have to, but that's your right. All right. Good afternoon, Deputy Bills. Nice to see you. Could you please swear or affirm under penalties of perjury that the information, that any testimony you're going to give today is the truth, the whole truth, and nothing but the truth?
I swear.
Okay, very good. Thank you, ma'am. All right, Mr. Bama, sir.
Thanks. It's okay if I stay seated?
Yeah, stay seated. There's no formality.
All right, state your name, please.
Caitlin Bills.
And were you employed as of 4/29/25?
Yes, as a corporal with the San Miguel Sheriff's Office.
And did you receive information about a traffic complaint when you were on shift?
Yes, sir.
And do you recall how you received that information?
Via San Miguel County Dispatch over the radio.
And what information did you receive?
Information about a black Jeep Wrangler or Rubicon Jeep that had a pink crown in the back window with temporary plates that was going a slow amount of speed on Highway 145, mile marker 19, and that was failing to maintain a single lane as the vehicle was driving towards Norwood.
Mr. Adams was concerned. Well, what was he concerned about when he made the call?
The driving behavior of the Jeep and the fact that it was going slow and failing to maintain lane, while also when he had passed that vehicle, he had smelled marijuana and seen the driver smoking what looked like a marijuana cigarette or something along those lines to him.
Mr. Adams had to actually pass this vehicle in San Miguel County to get around safely.
Yes, and he also had to hit his brakes because the vehicle was going so slow, so it impeded his traffic when he was trying to drive and his safety as well.
Okay. Eventually, did you come in contact with the Wrangler?
I did, in the town of Norwood on Grand Avenue.
Why did you initiate a traffic stop?
I had seen the Jeep Wrangler stopped at a stop sign on Grand Avenue in North Pine, and it had sat there for an extended period of time, then quickly turned into the marijuana shop, Alpine Wellness, in Norwood. Within less than a minute, it had pulled in there. He had given good descriptors of exactly what he had seen and observed and smelled. I initiated the traffic stop and contacted the driver, Jacina Ragu.
And what was your tone when you first initiated the stop?
Conversational. Well, when I first started it, I had yelled stop at her because she almost backed up into my car. But after that, it was conversational.
That's probably a smart choice. But you know what would have been even smarter? Not driving while using substances, especially with your 3 young kids in the car. That decision alone could have put everyone in serious danger. After that, the next best move would have been hiring an attorney instead of trying to handle everything on your own.
With the defendant at the time of the stop?
Yes. Her mother-in-law was the passenger, and then she had 3 young children in the back seat.
And eventually, you do have a conversation with the defendant, and I'll say that that's beyond the scope of what we're talking about today, but just to kind of paint the complete picture, you have a conversation with the defendant, and then is she ultimately charged with driving under the influence of drugs?
Yes, sir.
Okay. And did she consent to any tests?
Yes, she consented to voluntary roadside maneuvers.
And how about any chemical testing?
Yes, she consented to a chemical test of her blood, and when she consented, she said that there would be THC in her blood.
Okay, and what else did she tell you anything else when you were conducting your investigation?
She had told me that she had smoked marijuana. It had been outside of her car, and this was after she initially had lied to me about that she hadn't smoked at all, and she changed her story. But she had pulled over and she had smoked outside of the car, and it had only been 1 joint, even though the car smelled like burnt marijuana on the inside, and there was burnt marijuana cigarettes that were visible in the ashtray.
Okay. For the purposes of this hearing, those are all the questions that I have.
So, Ms. Raby, this is now your opportunity to cross-examine Deputy Bills about anything that she offered as testimony. If you'd like to do that, you're welcome to go ahead. You don't have to do it, but it's your right.
I don't have any questions to cross-examine at this time.
Now that the facts are laid out, and it's clear there's probable cause that a crime was committed, and that the defendant was likely involved, we're moving on to the next part. This is where the judge goes through her motions, one by one, and denies each of them. It's a key moment because it really shows how the court handles attempts to derail or delay the process, and it gives us a better look at how this hearing is about to unfold.
Hereby excused. Ms. Bills, thank you very much for your time and appearance today. I appreciate your working with the WebEx machine as well. Okay.
Yeah, sorry about that. Have a good day.
No worries. Okay. Do the people have further argument or evidence or presentation?
No further evidence. Ready to make argument. I don't know if I think just for protocol,
Ms.
I'm
Raby.
gonna open up to Miss Raby first.
Yeah. So did you want to, Ms. Raby, this is the time when you can make effectively what would be a closing argument, a summary of what your assertions are in support of your motion. Again, you don't have to say a word, but if you wanted to offer a global overview of what you're advancing in your motion, you're welcome to do that. Do you wish to do anything like that?
No, everything that I have to say is going to be written to you in certified mail.
Mr. Bamasir, do the people wish to make
Yeah, thanks. In order to make a traffic stop, the police must have reasonable suspicion that a person has committed a traffic violation or other offense. Suspicion is reasonable when there is an articulable and specific basis in fact to support it, and the police must have specific and articulable facts or rational inferences from those facts would support a reasonable suspicion of criminal activity and thereby justify the intrusion into the defendant's personal activity. The reasonable suspicion here was articulated by Deputy Bills, and it started with a citizen informant or ready report, if you will. And the ready report is something that has been dealt with in Colorado courts before, and they can serve to justify or create that reasonable suspicion. And I think in this specific case, that reliability is all the more established based on the fact that this was a trained law enforcement officer, albeit he was working for the jail at that time, not necessarily a patrol officer, but still law enforcement and still understands what's required when you're calling in a ready report. Also, peeling in front of the marijuana store and almost backing into Deputy Bills during the stop, again, that just leads to the reasonable suspicion for this stop. And the site that I'll have there is kind of the cumulative reasonable suspicion is People v. Garcia, 789 P2D 190192, Colorado, 1990.
As mentioned earlier, all of her unrelated motions, including the ones that bring up the Uniform Commercial Code, have been denied. With that out of the way, the only thing left now is for the judge to set the date for the next hearing. It's a simple wrap-up, but it shows how quickly the court moves past arguments that don't hold any legal weight.
Thanks, Judge. This is Mr. Montez, number 36.
#22 CR 7002, People versus Montez. Entries?
Daniel Cohen on behalf of the people.
And Robert Halpern on behalf of Mr. Montez, who is present in custody in the courtroom today.
I was set for sentencing today.
That's correct.
Ready to proceed?
Yes.
Yes, Your Honor.
Prosecution?
Thank you, Your Honor. I will just initially note, well, as the court is aware, this is a case that it's a fairly small range sentencing between 20 and 25 years. I am going to be asking for the 25 years. I
thought it
believe.
was, did I typo? I thought it was 24.
Sorry, 2024. Pardon me. That was the older. The previous one was 2024. I'm asking for that 24 years. I know. I think we're all aware of Mr. Montez's situation, but at the end of the day, this was a very violent assault against peace officers when they were trying to enforce the law and protect the peace and sanctity of the Denver Union Station bus station. As someone who has regularly used that bus station, I know how harrowing it can be at times. And I know the amount of work that RTD has put into that to try and make the public transportation system safer in this city. It's necessary for so many people, and for some of us, we want this RTD to be safe and enjoyable for everyone. And Mr. Montez, through his actions, severely disrupted that. And I believe that based on the nature of his offense, he has earned those 24 years. I will say that in preparing for this trial, in speaking to some of the officer witnesses, one witness, what stood out in my mind is when I asked him, what did you think when you saw what happened? He told me, my first thought was I just lost a colleague, because the stabbing was just that violent and aggressive. And thankfully, the officer who was stabbed repeatedly in this case, his vest did exactly what we hoped it would do. It prevented him from receiving any further serious injuries. It prevented him from being killed. But there were lasting effects in this case. The officer whose hand got cut suffered a fairly severe infection as a result of that, and is, I believe, still on desk duty as a result of that. His hand has never really gotten back to full functioning. This has affected a lot of people in a lot of different ways. There's a very large restitution amount, and I don't know if I haven't had a chance to talk to Mr. Halpern about this, so I will state that it's in excess of $20,000. So if I could have an opportunity to file a written motion, because it's divided between multiple different officers and expenses, so if I could have permission to file a written restitution request after conferring with Mr. Halpern about it, and I can get that done in the next week to week and a half.
To be heard before sentence.
Mr. Halpern?
Thanks, Judge. It's been a difficult case. It's obviously quite old, and I've gotten to know Mr. Montez throughout the pendency of the case fairly well, and I know he would disagree with some of my characterizations and my raising competency, but I've seen kind of the highs and lows, if you will, and when he is what I think functioning on a competent level, he's very smart, asks really intelligent questions about the case, about his options, about what happened that day, and he's taken responsibility for it. And it was, you watch the video, and that part of it is hard to watch when he has the scissors, but there is a long standoff, and that's in front of an elevator.
I watched the video.
Okay, and what Mr. Montez is talking about, and you hear it on the video, is at some point they do say that he can go. Once he puts the scissors away, they wanted him to get rid of the scissors, and then the doors open, and he did think he was free to go, and he got rushed. I think it's pretty clear that they weren't going to let him go given the circumstances, but he believed that and stepped back onto the elevator, and then they rushed him, and he reacted. And again, it's scary watching that reaction, and I'm glad they were wearing the vests. And I'm also glad that Mr. Montez, before the trial, opted for this option. While it's still a hefty sentence he's looking at, I would be concerned about post-trial and what he'd be looking at potentially the rest of his life. Again, I'm not sure that Mr. Montez to this day agrees with the idea of mental illness and mental health. But again, I think when I've seen him on his medications and doing well, he is smart and thoughtful, and I would encourage him to wrap his head around that and understand that diagnosis. Obviously, that's the decision he's going to make, but when I've seen him at his best, he has a lot to offer, and I really wish him luck moving forward through the prison, and then when he's released, and how he handles that in the future. But I know he wants to speak, and I do wish him the best throughout this process.
Hey, I'm free that day too. So October 28th works perfectly. Just make sure not to put your kids or any other children at school in danger by driving under the influence again. With that said, we're moving on to the next hearing, and this one's going to be a short one. It's more of a quick follow-up than a full session, but it's still an important step in the process.
All right, sir, you have the right to tell me anything you'd like me to know about this case and what your sentence could be. I really have no interest in anything else. Quite the only issue for this court is what should the sentence be.
All right, this is very important about the case and about the sentencing. Very important that my diplomatic community highest degree was automatically uploaded and in effect February 2023. It will be against my rights as a king and diplomatic community to prosecute me. Protocol. I am a king.
We've passed all that, sir. You agreed to plead guilty. The only question right now is, will I give you 20 years or 24 years? That's what you agreed to. So what is it you want? 20, 21, 24?
With diplomatic immunity highest degree, is what I'm trying to understand is that I'm not supposed to be prosecuted. So how is it
All right,
that
we're not having this discussion anymore, sir. You need to talk to me about the sentence.
At least.
Your record has been made. You have no diplomatic immunity. I'm sentencing you to 24 years in the Department of Corrections. There's a 3-year period of mandatory parole, and I will give you, what's his pre-sentence confinement credit?
1,043 days.
1,043 days of
Can we do
pre-sentence
20?
confinement credit, and we will determine restitution within 63 days.